Good afternoon, and thank you for joining today's webinar on NCPERS 2017 Code of Conduct for Public Pension Service Providers. My name is Hank Kim, and I'm the Executive Director and Counsel for the National Conference on Public Employee Retirement Systems. Today's program is part of our Center for Online Learning. The purpose of NCPERS Center for Online Learning is to provide remote continuing education to public pension trustees, staff, and other fiduciaries and stakeholders. NCPERS launched the Code of Conduct in May of 2015 to help set a standard for ethical behavior for public pension vendors. In today's webinar, we will go over this year's edition of the Code of Conduct and the accompanying Schedule A. As always, we encourage you to submit written questions and comments. Written questions and comments can be submitted by using the GoToMeetings dashboard. However, in order to get through the entire presentation, we will hold all questions and comments till the end. We anticipate the prepared portion of today's webinar to last about 30 minutes. Additionally, today's presentation and other supporting materials are available in the handout section, once again available on the dashboard. At the conclusion of this webinar, there will be a short survey question that we ask you to answer. So with that, let's get into a little finer detail on the agenda for the next 30 minutes. So first, I want to begin by doing a brief review of the purpose, history, and response to the 2015/16 edition of the inaugural NCPERS Code of Conduct for Public Plan Service Providers. Then I want to go into detail about the 2017 version of the code and the Schedule A. We've had couple of changes to the Code of Conduct. As we've mentioned at the beginning when we did launch this in 2015, that we view the Code of Conduct as a living, breathing, organic document, and that we will continue to refine it as the industry changes and as we learn more about the industry. And so we have a change that we'd like to highlight for 2017 in the Code of Conduct itself, as well as new additions to Schedule A. Then I'd like to talk about the Code of Conduct, the process and timetable that we utilize to annually update the Code of Conduct as well as the Schedule A. Then talk about the new resources available in 2017 for plans as well as vendors to get a better understanding of the Code of Conduct, to help implement and endorse the Code of Conduct and answer questions that we've fielded over the past 18 months or so. And then lastly, go over some of the action items for plans as well as vendors. And then obviously finally leave room for questions. So in terms of the purpose, we view the Code of Conduct as a tool that public plans should use to first articulate the strong, consistent ethical expectations that we have of our service providers, and also, part and parcel is to help identify potential conflicts of interest that may exist between vendors and the plans. And if those potential conflicts of interest are identified, to help begin a dialogue with those providers to resolve either the apparent or the real conflict. So, the real purpose, or I guess the bottom line purpose is, what we hope to achieve is that NCPERS can set a new industry best practice in terms of how we expect our vendors to behave, as well as providing a mechanism and assistance in beginning the conversations with the vendor community in terms of ferreting out potential conflicts of interest. And once those potential conflicts of interest are identified, again, begin the conversation with the provider community on how best to resolve them. So in terms of codes for an industry, it's fairly common. I think most people on the webinar are pretty familiar with the fact that asset managers have their own set of at least one set of professional conduct that is sponsored by the CFA Institute. Actuaries, all the various organizations in the actuarial community got together and created a code of professional conduct for actuaries. And in the legal profession, which I'm more familiar with, obviously we have the American Bar Association's Model Code of Professional Responsibility. And these are just three examples of professions that many plans deal with, but in the accounting industry and other professions and trades, there are these codes of conduct, and so it's not uncommon for a trade association or for an industry to come together and create a code that is expected of those who are participating in that community. Likewise, and I guess somewhat related, I think many people on the webinar are familiar with this map or variation of this map, which essentially shows the number of major pension changes that have been enacted over the last 10 years or so. And while we freely assert and admit that some of the pension changes were warranted and necessary for the sustainability of public sector pension plans, we also know that some of these changes were done in exploiting the economic and political atmosphere created soon after the Great Recession, and was largely pushed for ideological reasons and agenda. As partially as a consequence from that, there are a couple of organizations that we highlight in this webinar. For instance, American Federation of Teachers, who have identified that while again some of the reforms were necessary, in those reforms or pension changes that were enacted soon after the Great Recessions, there are plenty of examples where, again, it was done under ideological bent, and that the funding for these campaigns and the support of some of these campaigns to undermine public pensions were done by some of the very vendors and service providers that public plans use and pay. And so AFT, for their part, has issued their asset manager list, which highlights folks who they've identified as managers who've contributed to these unwarranted attacks on public plans. Similarly, the Texas Public Employee Retirement Systems, or it's I guess the Texas Association of Public Employee Retirement Systems, has as part of their membership for vendor community an acknowledgement that if they are to become NCPERS members, that they sign this acknowledgement saying that they support public pensions in the state of Texas. And most recently, just last year, the Department of Labor issued their finalized conflict of interest rules. This rule and various iterations of it was under review and under development for a number of years in the Department of Labor. It was done very diligently and thoughtfully, and finally the finalized rule came out in April of 2016 with the phased implementation beginning in June, and it essentially defines what a fiduciary is and largely, expands the requirements of a fiduciary to the retail side and to vendors of individual retirement accounts. And so, what I'm trying to show here is that the trend seems to be, sort of this defining and expanding and drawing the borders of who is a fiduciary, what are the expectations, and what should clients of these fiduciaries, what should they expect? And so, while NCPERS Code of Conduct, when we launched it in 2015 and 16, wasn't really done in consultation with any of these other developments, we just noted that there was a trend, and that in conversations with the provider community as well as with plans, that we thought, given our status as the largest trade association for public pensions, that we could play a part in the ever-developing conversations about ethics and what plans, and in particular public plans, should expect from the vendor community. So back in May of 2015 at our annual conference and exhibition in New Orleans, we unveiled the inaugural NCPERS Code of Conduct. And over the past 18 months, we've been able to, in partnership with plans that are both members and non-members of NCPERS, ask some of the vendor community to endorse the Code of Conduct. And here you see a list of number of firms that have signed on to the, signed on and endorsed the Code of Conduct. You will see that they are, stretch the gamut of the public plan vendor side. There are big asset management firms as well as boutique and private market firms. Number of actuarial and legal firms. Some administrative firms, as well as investment consultants. So, we think we got a good start, and again, we, thank not only these folks and the ones who've endorsed the Code of Conduct, but the plans who have reached out to their service providers and asked them to voluntarily sign on to the Code of Conduct. One of the things we want to have happen as we do the second iteration of the Code of Conduct is to grow the list, and so that we can highlight those service providers that have pledged to abide by the Code of Conduct. Some people, mistakenly viewed the Code of Conduct, particularly in the inception, as some sort of a blacklist. And, what I can assure folks, most affirmatively is that, in fact, it's not a blacklist. But what it is, rather, is to, again, underscore and highlight those firms who are voluntarily agreeing to abide by the Code of Conduct for the public plan community. And this again is not all that unique. Again, the CFA Institute, which we have a licensing agreement because our Code of Conduct borrowed liberally from the CFA Institute of Code of Professional Conduct. They, on their website, list all the entities that have signed on to the CFA Institute. So, what we want to do is grow the list, and again, just congratulate those service providers who are, going above and beyond what's expected of them as a public pension service provider. So, without further ado, I want to introduce the 2017 iteration of the Code of Conduct. Again, there are 9 points to the Code of Conduct, and I will just very briefly read through the 10 points of the Code. First and foremost is that those who endorse the Code of Conduct pledge to act in a professional and ethical manner at all times in dealing with public plan clients. 2, act for the benefit of public plan clients. 3, act with independence and objectivity. 4, fully disclose to plan clients conflicts of interest that arise that may impair the ability to act independently or objectively. 5, act with reasonable care, skill, competence, and diligence when engaging in professional activities. Communicate with public plan clients in a timely and accurate manner. Uphold the applicable law, rules, and regulations governing their sector and profession. 8, fully disclose to public plan clients all fees charged for the products or services provided to the client. And then 9 is where we made a slight change from the inaugural Code of Conduct. Instead of phrasing in the negative, we phrased point 9 in a more positive statement, which is support the sustainability of public defined benefit plans and retirement arrangements that add to overall retirement security. And then 10, fully disclose all contributions made to entities enumerated in Schedule A that advocate for the diminishment of public defined benefit plans. In regard to Schedule A, as I said, we made a couple of changes to Schedule A, and one of which is that we added a new category in terms of how we evaluate the nonprofits, think tanks, and foundations that are listed in here. And so we added a new category of miscellaneous activities to diminish public plan sustainability and retirement security. So as you can see from the list, we have a number of national and well-known think tanks, foundations, and nonprofits, and a number of smaller regional players and less well-known. Those that are identified with the asterisk after their name are new entrants to the Schedule A, so they were not included in the 2015-16 Schedule A. And in terms of the Schedule A as well as the actual Code of Conduct, this is the annual process that we use. Between September through November, NCPERS, we send out a request to our fund members asking for input. Given that our members are more than 500 strong in every single state, territory, and in Canada and Australia, we feel that you are the best indicators of where you're seeing research activity or nonprofit or foundation activity that unjustifiably and in a biased manner attack public plans. So when we ask for input, we ask that you submit back to us the name of the entity you'd like to be added to this, next year's Schedule A, a website so that we can look at the entity further if they do have one, and examples of Schedule A criteria that we would use. Once we get that, the staff reviews the submissions from our members. We document the supporting examples, and we prepare a draft Schedule A for the NCPERS Executive Board. Then at the NCPERS December Executive Board meeting, the full board reviews the Schedule A and any changes we may or may not have made to the Code of Conduct itself, and the board votes to approve the code if there's been any changes to the code, and approve the Schedule A if there have been any additions, deletions, or edits. As I said, we use an objective criteria when evaluating the submissions from our members, and so the criteria that we use are whether the nonprofit, think tank, or foundation advocates that public defined benefit plans are unsustainable, advocates for a defined contribution plan to replace the public defined benefit plan, advocates for a poorly designed cash balance plan to replace the public defined benefit plan, advocates for a poorly designed combination plan to replace the defined benefit plan, links school performance evaluation to whether the school sponsors a defined benefit plan for its teachers or employees. And then the new one is miscellaneous activities to diminish public pension sustainability and retirement security. So, having learned what the process is, I'd like to highlight a couple of analysis that we've done to help plans feel comfortable in reviewing the Code of Conduct and ideally adopting it as part of the plan and members' the RFP process. So one of the first things we did is we did a fiduciary analysis of whether this was part of the fiduciary duty that the Board of Trustees and the plan itself can do and should do. And our feeling is that based on our fiduciary analysis, the Code of Conduct is in fact something that plans should adopt and ask their service providers to endorse, that we don't see any barriers to providers or the vendor community in endorsing the Code of Conduct or signing and signing onto it and endorsing it. And the basic analysis that we use is that any person any person is a fiduciary to a pension plan to the extent that they exercise the discretionary authority with respect to the plan and its assets. So that, in our definition, is what a fiduciary is. If you exercise some measure of authority and discretion within the plan and its assets, then you are a fiduciary. Because of that definition, we feel that those service providers and vendors that do exercise discretion, therefore, are fiduciaries to the plan. As plan fiduciaries, vendors, like Board of Trustees and staff, must act solely in the interest of the plan, the participants, and the beneficiary. And if they take action that they know will harm the plan or its participants or beneficiaries, but will advance the corporate or personal interest, it is in breach of its fiduciary duty. Our feeling is that trustees and the plan should perform due diligence in terms of whether there is conflict of interest on its vendors to identify any potential conflicts, and if such conflicts are identified, then begin the conversation with the service provider to see how best to address that potential or real conflict of interest. So as it applies to the Code of Conduct and specifically to item 10 in the Code of Conduct, here is the hypothetical. If a vendor receives money for services or products provided to a public plan, and it uses corporate assets to make a monetary contribution to an entity that advocates for the diminishment of public defined benefit plans, then there inherently is a conflict of interest, and that the plan should begin a conversation with that service provider to see how best to resolve it. And in many instances, a conversation may be the only thing that's needed. For instance, if they did make a contribution to the Heritage Foundation, but the contribution was for the Heritage's work on infrastructure, and did not support any of its work on public plans, then there is no conflict of interest. And the plan did its due diligence in trying to find out whether that initial perceived conflict of interest was real, and by having that conversation with the vendor, and if it turned out that the vendor contributed for research that was separate and apart from the work that Heritage does on public pensions, then there is no conflict. So, just to underscore, just because the Code of Conduct identifies a potential conflict of interest, it does not mean that the vendor or the service provider needs to be terminated automatically. Rather, again, as we stated at the beginning, we want to see this as a tool to begin the conversation about potential conflicts of interest, reaffirming that the vendor views itself as a fiduciary to the plan, and that where there is a potential conflict, begin the conversation to see how the plan wishes to work with the vendor in terms of addressing and resolving that conflict. Now, in terms of the First Amendment, this First Amendment analysis is brand new for 2017. A number of plans came to us and said, "Hey, what about free speech?" And quite candidly, when we were developing the Code of Conduct, we didn't think about the need, but as a plan or two brought it to our attention, we thought about it and deliberated, and in fact, it is an issue, and therefore we spent the last 8 months doing a legal analysis with one of our outside legal law firms, and we drafted the First Amendment analysis, which is part of the supporting materials that I'll mention in a few minutes. So at the onset, I will say I am not a First Amendment expert, although I do play a great one on a webinar, and I did stay at a Holiday Inn Select last night, so I feel pretty confident about what I'm about to say, but I do want to make that caveat known. And as with the First Amendment analysis and with the fiduciary analysis, we encourage plans to consult their plan counsel to see the views of your legal team. So first analysis that needs to be done, and it's somewhat rudimentary, but it makes sense to start at the beginning, which is the First Amendment protection. Who does it apply to? And so I think First Amendment, it's very misunderstood. I think by the average American, they think that First Amendment applies to everybody, but in fact, First Amendment limitation really only applies to state actors. So, the federal government, state and local government, if you are an arm of the state and you impede speech, then you may be under First Amendment issues. What about private citizens? Well, private citizens, the First Amendment really doesn't apply. So that's why, in my household, I can tell my kids to be quiet because, you know, I'm not a state actor in my house. Likewise, you know, I think one of the videos that went viral from some of the protests that occurred about 1.5 years ago in Baltimore during the Freddie Gray trial was a mother, you know, essentially pulling her son away from one of the more violent protests in the streets of Baltimore. And again, she could do that because she's a private actor. If a state actor actually tried to do that to some of the protesters, then there would be some First Amendment issues. So again, First Amendment protection on freedom of speech only applies to state actors. So then the next threshold question is, are public plans state actors? I think, again, this is pretty much a throwaway question, but it needs to be, you know, analyzed. Yes, I think the vast majority of public plans are state actors. There is one public plan in Michigan that is actually organized as a 501c3 nonprofit. But I think even in that situation, given who the participants are and who the contributors are, I think it would be very hard to state that even though it's organized as a nonprofit, that pension plan would not be considered as a state actor. So then the next question is, in regard to item 10, is monetary contribution speech? And there is a long line of Supreme Court cases, beginning with Buckley v. Vallejo, that says money is speech. So yes, so right now we say public pensions are state actors, so First Amendment infringement applies. It applies to contributions made to nonprofits because money is speech as it's currently understood. And so then the next question is, can a public plan place limitations on speech? And in our analysis, we say we can. I think first we need to acknowledge that while the freedom of speech and expression is a fundamental right, it's a well-established law that it is not an absolute right, and therefore there are some exclusions from the freedom of speech, as well as some limitations that can be placed on freedom of speech. So some of the exclusions are for inciting people to lawlessness or imminent harm. So one of the most famous quotes in regard to First Amendment speech is, speech that would incite imminent harm, such as yelling fire when there is no fire in a crowded theater, is excluded from First Amendment protection. Then there are other, restrictions that states can place on speech. Some of it is known as time, place, and manner restrictions. So, for instance, when you have a political protest, one of the most fundamental speeches there is, you still have to apply for a permit to hold that protest or rally. The state actor can place durations and limitations on where that speech or protest is held, and what location it can be done. So again, First Amendment, it's a fundamental right, but there can be restrictions and exclusions to it. So then the question is the NCPERS Code of Conduct a permissible limitation on speech? Our feeling is it is, that there is strong line of Supreme Court cases that says restrictions on speech will be upheld in circumstances where the harm that they're trying to prevent is significant and the means of the restriction is no broader than necessary. That is it narrowly tailored, and is the counterbalance competing interest significant? And so in our analysis, the competing interest of First Amendment, the competing interest against the First Amendment protection is the fiduciary responsibility of the pension plan to make sure that it acts in the sole interest of the plan, its participants, and beneficiaries. Is the restriction on speech narrowly tailored? That is it overly broad? In our view, we think the Code of Conduct is very narrowly tailored. The Code of Conduct doesn't say, every political speech is prohibited. We just merely, ask for information on speech that is related to the very survival of public pensions, and we think that that given the nature of the speech and what we're trying to tailor it to, and the competing interest of being a fiduciary, that it will survive. It can survive a court challenge. Is it a definite that it could survive challenge? I mean, in this political day, who's to say? But I think given good reasonable interpretation of First Amendment, we think it can survive a First Amendment challenge. And from my personal view, I think the culture of our world is changing, and so I am not a strict constructionist or an originalist that believes that the Constitution should only be interpreted as it was written in the 1700s. I think in this uber fast-paced world of social media, where public employees are being terminated, or in other fashion being sanctioned for private speech on their social media, that a vendor who has an opinion about public pensions, in this broader world, I think the court, or a court could take a little bit nuanced view on what is narrowly tailored. So what do we ask of our members, both on the corporate side as well as the plan side? So if you think the Code of Conduct is necessary and you believe in it, we ask fund members to incorporate the Code of Conduct into the RFP process, invite current service providers and vendors to endorse the Code of Conduct, and as you, the plan, endorse it or incorporate it, and as your service providers endorse it, please let us know, and we'd like to keep track of all the service providers that are going above and beyond, their ethical expectations. So, as I mentioned, we do have an implementation packet that we think helps you adopt and endorse the Code of Conduct. You can see it on our website. On the website you will have access to the actual Code of Conduct, to the Schedule A, the Schedule A chart, which shows why the various nonprofits are in the Schedule A, and which part of the 6 objective standards that they violated. Again, an outline of what the annual process is, a model motion for plans to use in order to adopt the Code of Conduct into their RFP process, the Code of Conduct Fiduciary Analysis that we briefly went over in this webinar, and also the First Amendment analysis, again, which we went over in this webinar. Frequently asked questions, which is part of the handouts that's available in this webinar as well as on the website. And those plan service providers who have endorsed the Code of Conduct for 2017, as well as we have archives of the folks who signed on in 2015 and 16. And then last is letters of intent. These are service providers who, for various reasons, could not actually sign on to the Code of Conduct, but sent us letters essentially saying that they abide by the principle that they are fiduciaries of public plans, and that while they cannot officially endorse the Code of Conduct, that they keep to the spirit of this Code of Conduct. So in terms of some of the other educational programs that are available, we have our Accredited Fiduciary Program, TEDS, and annual conference coming up in May. Then in September, we have our annual Public Pension Funding Forum. This year, it will be hosted at Stanford University. And then in conjunction with the Public Safety Program, we have the fall edition of the NCPERS Accredited Fiduciary held in San Antonio. So at this time, I'd be happy to answer any questions that folks may have. So one of the questions that came in is, if someone makes a contribution to the code to the Schedule A, and they acknowledge that to the plan, can they still endorse the Code of Conduct? And the answer to that is yes. Again, we view the Code of Conduct as a tool to begin a conversation with your service providers to see what the potential conflicts of interest there may be, and if your vendor discloses their contribution, and that's what point 10 only seeks. We want disclosure, and so if they disclose it, and then they're free to sign on to the Code of Conduct. Now, for the plan, I would say that you should have some further conversations regarding that disclosure. And again, as the hypothetical I gave earlier in the webinar, find out what the purpose of the contribution was. And if the contribution was for something that's unrelated to public pensions, then I don't think there's anything further you need to do. If in fact it was related to one of the research materials that takes a decidedly anti-public pension position, then I think further conversations with that vendor is required. And then, and depending upon how those conversations go, additional internal discussions may be warranted within the plan. So at this time, I don't think there's any other questions, so I want to thank you for tuning in. I do want to bring to your attention that the next NCPERS webinar will be a month from now on March 7th, and it will be on NCPERS Affinity Program. So thank you so much for tuning in, and I'm sorry, wait a second. We just got another question. So the question is the freedom of speech issue really just an issue for the boards and NCPERS and not the service providers who signed this? Yes. The First Amendment question really goes to a state actor, and I think public plans are state actors, and in this instance, the state actor, a public plan, if you adopt the Code of Conduct, there could be allegations that you're infringing your vendor or potential vendor speech. But as I think our First Amendment memo and analysis shows, that this is a permissible speech because it's balancing two competing interests. The competing interest of the state actor, in this instance the pension plan, to abide by its fiduciary responsibility in ensuring that there's no conflict of interest, and the vendor's First Amendment right to state a position that is against public pensions. But we feel that, again, because it's narrowly tailored just to the issue of public pensions, that it's permissible infringement on speech. As for NCPERS, NCPERS is a private, non-for-profit organization, so we have no First Amendment issues. And therefore, that's why we freely and strongly ask our corporate members to sign on to the Code of Conduct. So the other question is, what actuarial services involve discretion such that actuaries would be fiduciaries? That's a great question. That's one of the things that we modified from our fiduciary memo from 2015. So the new memo that is updated in January 2017 actually takes out actuaries as a fiduciary because they do not have discretion and therefore are not considered fiduciaries. Okay, so I think that's all the questions we have. Again, we thank you for your participation. We ask you at the end of this webinar to take a very short 3-question survey that will help us inform and develop better programs for the Center for Online Learning. So in conclusion, thank you so much, and we look forward to seeing you on March 7th.